Honorable Court of Appeals for the Fourth Court of Appeals District of Texas is now open pursuant to call.
Good morning. Have a seat. I'm Justice Lori Massey-Brissett. With me I have Justice Adrian Spears and Justice Belia Meza. We are happy to be here in Kerrville this morning. Thank you to the county officials that have done such a great job of making it easy for us, and to our staff, Caitlin and Dell, that came with us. I will call the case of 0420-00486 CR, Williams versus State of Texas. Can I have announcements?
Mark Bennett on behalf of the Institute for Advanced Criminal Law Studies for Mr. Williams.
And who is with you?
This is my clerk, Nick Wade. He's been back by 16 so he doesn't get kicked out of law school.
Wonderful. But you won't be splitting time, obviously.
Won't be splitting time,
Okay.
Mr. Wade. He's letting me do this myself.
And are you reserving any time?
I believe that the court gives 20 minutes for our initial and 10 minutes for our,
Right.
well, we're not asking for anything.
Okay.
That's perfect.
Thank you.
David Schulman for the state, with me is Ben Rosenbach, who's here, but
Not splitting time.
So I'll take my first 20 minutes.
Thank you. Thank you. Holly, you can proceed.
May it please the court. This court in the first go-round made the right decision for the wrong reason. Unfortunately, unlike the state, the defense doesn't get the benefit in the Court of Criminal Appeals of the right result, wrong reason rule. The right result was that the case was reversed and ordered dismissed because the trial court had erred in denying a motion to quash. The wrong reason was that this court found that the state should have been required to more specifically to specify which of the 6 different theories of aggravated promotion of prostitution it intended to rely on. Mr. Schulman and I were talking just before argument about the equitable and the legal. And equitably, I think that it's clear that the state should have been required to specify fewer than the 6 of the different theories of committing this offense. I say that because allowing them to throw in the kitchen sink in bad faith with no intention to prove 3 of the possible theories of committing the case just shouldn't be allowed. That just doesn't make sense. It couldn't possibly be the law. However, the law allows them to do that, and that's why this case got sent back. However, what the law doesn't allow them to do is to specify these 6 different theories of committing aggravated promotion of prostitution. And I use theories because it's neutral. We're going to have a fight probably about whether these are elements of separate offenses, which each require unanimity, or whether they're manners and means of committing a single offense, which don't require jury unanimity. So for purposes of our first point of error, which is the failure of the court to grant the motion to quash, I'll use theories of committing the offense. And if you look at recent opinions from the Court of Criminal Appeals, for example, last week there was a case called Al-Kayali, A-L-K-A-Y-Y-A-L-I, decided last Wednesday. Judge Yeary, in his concurrence, described the different manners of committing murder as different theories, because there had been some dispute there about whether they are in fact manners and means or elements of separate offenses. In this case, however, the state has pled 6 different theories of the offense, and there's 6 different verbs.
Can I ask you a question about
Al-Kayali?
You said the issue was, I haven't seen the case, so you said the issue was whether or not they were manner and means or separate offenses. Did the court address that issue?
It didn't need to.
Okay.
It affirmed it was a state's, I may have this basic procedural fact wrong on a case that I argued. It held that that there was egregious harm from a jury charge that didn't include one. I see my Mr. Schulman here nodding his head.
He's agreeing with you.
The jury charge didn't include the causing death element of a 19.02b2 murder. And if the court's not familiar with the forms of murder, there's B1, which is intentionally or knowingly causing the death, and there's B2, which is intentionally causing serious bodily injury, with intent to cause serious bodily injury, committing an act clearly dangerous to human life that causes the death. The jury charge in the application paragraph of Al-Kayali left out that cause the death in the second portion. We raised it in our argument. It hadn't been raised below. It wasn't necessary to the decision on the case. But Judge Erie touched on it, because I know that this is an issue that is of great interest to Judge Erie. And he noted that, that it's at least an interesting issue, but he referred to the different ways of committing murder, that B1 and B2, not as manners and not as elements, but as different theories of murder. But getting back to why the right reason for this, the result that this court gave last time, is a case called Mays, which is that when a defendant asks for more detail of a statutorily undefined, indeterminate term, that he's entitled to it. He's entitled
Real quick, on
to
this,
that notice. Yes.
on undefined terms, you're talking about owns, invests, finance, controls, supervises, or manage,
Correct.
and you're saying that those aren't enough to give the defendant notice of
Correct.
what's being charged with?
Yes.
How so?
Okay.
Explain that to me.
So first of all, undefined means undefined by the statute, and I think we can all agree that those are not statutorily defined.
But if they don't need to be defined because it's common usage of the language, does it need to be statutorily defined?
Right, so if there were only one meaning to the word, then the defendant wouldn't be entitled to specific notice. But the dictionary actually doesn't answer the question, and
In the result, I mean, a promotion of prostitution, no matter which one of those you use?
so that, yes, that is the title of the statute. And the state argued in one of its briefs that promotion is implicit in the statute, which is nonsense, of course, because you don't have implicit elements of an offense. So yes, they're all directed toward promotion of prostitution, but that doesn't make them specific enough that the state doesn't have to give notice on request of how it intends to prove them.
And you don't think you can take all those words as a whole to mean basically the boss, the person who's benefiting from this
no.
promotion?
No.
You think they're all
No.
separate?
Well, I think even different questions, right? One of them is, are they manners and means, so that a jury could look at it and say, well, we all believe that he did one of them and therefore we're going to convict him, is a separate question from, is specific notice required? Because specific notice is required on manner and means as well. And the dictionary isn't an answer to the Mays question, despite the state briefing it that way. State spends a great deal of time making an argument from definitions, right? Oh, this is what the dictionary says. But on page 25 of our brief, we have 6 different examples of words that were held to require greater notice. Start a fire, right? Well, there's only one definition to start a fire, but you can do it lots of different ways. Torture a dog. Nobody's going to say that torture a dog is some vague term on its own, but you can do it lots of different ways, and the state was required to plead, to give the defendant notice of how he had tortured a dog. Cause bodily injury. We see this in assault cases all the time. The state has to give notice. It's not that cause bodily injury is some vague term. It's that there are lots of different ways to do it. Destroy property, threaten, receive bets and offers. All of these are at page 25 of our brief, along with the sites in which the Court of Criminal Appeals has approved of, or at least Texas courts have approved of, requiring more notice.
Can we go to the 8th grade grammar test?
The 8th grade grammar test is on our second point of error. And the 8th grade grammar test, the Court of Criminal Appeals has said that you distinguish between an elemental act and a manner and means because they are, the main verb of the sentence is an element. And of course, the Texas legislature agrees with this. Article 1.07A22 of the Penal Code says that an element of the offense includes the act. That main act, if there is a main act, is an element. Manners and means are generally defined by an adverbial phrase. So I'll give you an example. Outside the law, I cook a steak. I cook a steak by grilling it. I cook a steak by boiling it. I cook a steak by roasting it. I cook a steak by pan frying it. The main verb is cook. I cook a steak. And the different manners of doing that are broiling, frying, boiling, grilling, right?
And so when the jury is instructed on your cooking the steak,
Yes.
it doesn't matter whether you grilled it, boiled it. What matters is they proved an act of cooking.
The act of cooking it, exactly. That's the
act?
element.
What is the act of aggravated promotion?
There are 6 different parallel acts. Each of them is a main verb. There is invest, there is, I'm
But
sorry, I
that's the
never remember.
problem, that there's no unanimity in the jury verdict if you don't specify.
Well, so the way to resolve the problem would have been a jury charge saying, if you agree beyond a reasonable doubt unanimously that he managed, or if you agree beyond a reasonable doubt unanimously that he owned, and so forth, for all 6 of the verbs, or
Why do you have to separate them out? Why can't you put them all in the charge?
because they're elemental. And they're elemental for 3 reasons. One of them is the 8th grade grammar test. These are not in an adverbial phrase. An adverbial phrase would be, for example, it's a crime to promote prostitution by owning, investing, managing, and so forth.
And you're saying that they're not manner and means, or are you conceding? that-
No, they are not manner and means, but that's our second point of error. And this court doesn't even need to reach it.
I was
Because,
just wondering, 'cause you mentioned Mays, I figured if it's manner and means, Mays has an exception that you have to specify, right?
well,
What does Mays stand for to you?
so Mays stands for the proposition that if a verb in a charge, in a statute, is not statutorily defined, that the defendant is entitled to a description from the state of how he did that thing, causing injury. For example, causing is elemental. We agree on that, right? But if the state says you caused injury, then we're entitled to, on request, we're entitled to notice of how they contend we caused the injury.
But real quick on the harm of this, is it your contention that the defense would have been different at trial?
Of which?
Of
Are we talking the first point or the second point? Sorry.
the first point on the promotion, aggravated promotion charge? What
So-
would you have, what could have been done differently to make the
I
defendant
didn't
notice?
try the case. What we're guided by is Article 2119 of the Code of Criminal Procedure. This is an error in form. And what the Code of Criminal Procedure says is that an error in form is not reversible if it didn't prejudice the substantial rights of the defendant. That if is really important because it creates sort of a presumption of prejudice of the substantial rights, right? Because, I won't go outside if it's raining, suggests that I'm going to go outside, but if this one condition exists, then it's not going to happen. So 2119 says if it doesn't prejudice the substantial rights.
And you're saying this is prejudicial?
I'm saying the record doesn't show it's not prejudicial. In order for 2119 to make it not reversible, the record would have to show, and this isn't putting the burden on the state, although the state could have, if in fact they had given notice, could have shown that at trial. If they had given him notice of how they intended to prove these things, they could have shown it at trial. So it's not.
So if we review the record and we don't find any surprise and we find that he was able to put on an adequate defense, doesn't that show that his rights were not prejudiced?
No, because we can't tell that from the cold record. We can't tell what he would have done had he had notice. What would show that he wasn't prejudiced, if it were true, was that he actually got notice in some other form. And the state has said in their brief, well, the record doesn't show that he didn't. Yeah, but it doesn't show that he did. And in fact, I would argue that it does show that he didn't. And here's why. We know 3914 was not complied with in this case. Article 3914 of the Code of Criminal Procedure, which requires discovery in criminal cases, was not complied with, and I can prove it on the record. How I can prove it is 39.14J requires that the parties file a statement with the court of what discovery was provided. There is no such thing in the record here. 39.14J was not complied with. We can't presume that 39.14A, which requires production of discovery, was complied with. And so there's nothing in the record showing that he had the notice that he needed to prepare for trial. In fact, I would have tried this case a different way than Mr. Williams's counsel would have. We can't tell from the cold record whether it would have been a better way or a worse way, but that's the same sort of question here. It's not the record, in order for an error of form to be reversible, the record has to show that it didn't prejudice the substantial rights. And in the first go-round, this court found that the record didn't show that and found that correctly. I think maybe that's law of the case. I don't think it's a really disputable issue now. The best that the state can come up with is, well, there was a right to discovery, so surely discovery was provided. There was a right to 3914J filing, and that wasn't provided. Why should we assume that anything was done correctly if 3914J? It's like the brown M&Ms. the story of the brown M&Ms is, you know, I think it was Led Zeppelin, did these huge rock shows, and in their contract, they had 100 pages of contract. In the middle was a bowl of brown M&Ms. Why? Not because they wanted brown M&Ms, but because they knew when they went into the room that if there wasn't a bowl of brown M&Ms, the contract hadn't been read.
Real
Right?
quick, I'm gonna stop you there for a second.
You don't like my brown M&Ms?
No, I do,
Justice
but I
Spears?
just, I had a
I'm
thought.
vamping here. I got 6 more minutes.
Well, okay, so when you look at these, you call them different crimes, right? All 6 of these?
For purposes, yeah. So for purposes of our first argument, I would say
Okay,
different
the
theories. For purposes of our second argument, yes, they're different
Okay.
crimes.
And you're saying that, I mean, for statutory construction, we can't say a common meaning or a common definition of these terms, or
I'm sorry?
you're saying that they have to be defined in the statute, we can't use a common definition?
No, that's not what I'm saying. I'm saying that we give term, under the Code Construction Act and in jury charges, we give terms their common meaning, and the dictionary is an indication of what the common meaning might be.
And you're saying that all these mean different things?
I'm saying well, they could mean the same things. That would be sort of the conceptual groupings argument that I think the state has made and then abandoned. They could mean similar things. For example, invest and finance could be the same thing. But invest and own aren't the same thing. You can invest without owning, you can own without investing. Invest and manage aren't the same thing. Own and manage aren't the same thing. I'll give you the example of Target, right?
Wait.
I can own a share in Target, I don't manage a Target.
Let me go back to your cooking the steak analogy.
Yes.
Because you're using cook as equivalent to manage, invest, finance, right?
Correct.
What if cook is actually the promotion of prostitution and the grilling, roasting, et cetera,
Yes.
is the manage, finance, invest?
And if the legislature writes the statute that way, then these will be manners rather than elements, but the legislature didn't. If they'd written the statute to say it's a crime to promote prostitution by owning, investing, and so forth, then these would be statutory manners of committing the offense. They didn't do that, and it's not
the word
implicit.
buy in there?
Well, you'd have to have the word promote in, and I think by would be the best way to connect by, you know, the main verb, in that case would be promote, rather than a list of 6 parallel main verbs, which is what we have here. So then you'd have this main verb, and it would be hard to dispute that the bys, the different ways of doing that, were manners or means.
And then you have to say, it has to say promote in the statute, in your opinion.
If you're contending that promote is the main verb, it has to be in the statute. There aren't.
Can't be the title of the crime?
No, the Code
itself?
Construction Act, again, doesn't, the title of the statute doesn't limit the meaning of the statute, which is what elements do. If you think about it, an element limits the scope of the statute. The more elements you have, the narrower it
But
is.
it's not a factor in code construction at all?
It's not a, it doesn't limit or expand the meaning of the statute. I'm not saying it's not a factor at all. It can come into play. But it's not, but the title isn't an element of the offense. And we know this because sometimes the legislature will change the title of a statute without changing the content of the statute. They did this with online harassment, which is now known as online impersonation. Without changing the language of the statute, they made online harassment into online impersonation. It didn't, you know, it guides courts in deciding what the actual elements of the statute mean in the trying to narrow the First Amendment scope of it, but it doesn't define the statute. And that's, you can't have implicit elements because people have to have notice of what's forbidden. And the elements of the statute, we assume that people read the statutes. Of course they don't, but we pretend that they do. And the elements are what they read to figure out what they're not allowed to do. Not the title of the statute. The title, you know, your title might have nothing to do with what the statute actually would mean to a living human being. So, right, so they could have written the statute the way that the state wants them to have written the statute, and that would make these manners or means. Again, that only comes into play in our second, or if the court.
Let's pretend that they are manner and means. Do you think the charge was still in error?
Yes. Well, I'm sorry, the charge. No. If they were this all hinges on them being elemental rather than manner and means. If
So
they were manner and
if it
means,
was manner and means, it would be okay.
the charge was okay if they were manner and means. The 3 things that define whether things are elemental are the U.S. Constitution under Apprendi and Elaine, the Texas statute, Article 1.07A22 of the Section 1.07A22 of the Penal Code says elements of the offense means, and includes the act and its included mental state, and then the 8th grade grammar test. And under all of these are elements. They're things that must be proven to a jury beyond a reasonable doubt. Now, the thing that we haven't talked about yet, and this is, so the state didn't write about 1.07A22, it didn't write about Apprendi, it didn't write about Elaine, it didn't write about the 8th grade grammar test. It's avoiding all of this. But the other thing that they didn't write about is Ramos versus Louisiana, which is the 2020 U.S. Supreme Court case that suddenly makes the U.S. Constitution care what elements are in state cases. Because before that, the unanimity wasn't required in state verdicts. But post-2020, the 6th Amendment requires unanimity in state verdicts. And if the 6th Amendment requires unanimity, then the 6th Amendment has to ask, okay, what are the elements? And we know what the limits on elements are because of Apprendi and Elaine. And I've got 53 seconds. I'm happy to sit down and let Mr. Schulman talk at you for a bit. I will, of course, come back, unless you have any more questions right now. Thank you.
May it please the court, counsel. Before I start, I want to point one thing out. I'm unfamiliar with what we used to call what's in the chucks that you look at. And I want to point out that on the court's online docket sheet, it does not reflect our response to the amended supplemental brief. So if you haven't, if it's not something you see because you go to the online docket sheet, please look at our response, which was filed on June 5th of 2024. Now, and of course, we stand by everything we said in that response. Where to begin?
Mr. Schulman, can you start where he left off, that these are elements?
Yes, thank you. Judge Keller cleared that up in very early on. I believe it is at second page of the opinion in Williams 2, the Court of Criminal Appeals opinion, when she referred to, I guess it's alternate methods, alternate statutory methods of proving the offense. Now, you're not going to find manners and means.
Did she rule on that, or did she assume it for the purpose of the opinion?
I would say that was her rationale. And to be candid, I think it was very much in answer to the argument being made by appellant. You won't find manners and means described in a statute. You won't find elements described in a statute. And what I would say to begin with about Ramos is what's an element and what's a manners and means is a state court decision, state rule decision, which whatever the Supreme Court says is not necessarily binding on the state of Texas. And in the opinion, bear with me.
Real quick, do you see this as a result of conduct crime? In other words, as counsel said earlier, that promotion of prostitution isn't part of the crime, even though it's called that. What's your take on that?
No, I would say that is the crime. And to be candid, the 6 items we're talking about, that's what it means. If you do A, B, C, D, E, or F, that's the offense. Now, admittedly, the issue is elements, manners and means, alternative statutory methods. But I would point out that early on in the opinion of the Court of Criminal Appeals, they point out that all these claims are forfeit or waived because he did not raise the claim at the trial court and the Court of Appeals. He waives, like for example, the separate offense issue. This is waived. This becomes
But
important.
don't we have discretion to take it up on supplemental briefing?
Ma'am?
Don't we have discretion to take it up?
Do you, the court? Yes, but you didn't. And the Court of Criminal Appeals has said they're waived or forfeit in their opinion. I'd say this becomes important because the appellant was represented by counsel in trial, but on appeal he chose to represent himself this court remanded the case for a hearing where the trial court admonished him about all the dangers, et cetera. And I've read that again. It goes on for quite a time. It was clear the defendant was told, you know, you could screw this up, and too bad. And yet he decided to represent himself. And so what I'd say is the court should be aware of that. And anything that's waived because of the failure to bring it up at the Court of Appeals the first time, it's waived. Cannot raise it again.
So you're saying we have no discretion to hear unassigned error? Is that your position?
Yes, in this case. It seems, let me go back to, it seems to me that what the appellant is trying to do now is to convince you to say the Court of Criminal Appeals was wrong in its decision. And of course, they're the only ones that can say that. But the other thing too is, it has occurred to me, mind you, I appeared early on in this when there was a change in DAs and they couldn't get together, so I appeared to ask for an extension. And I've been involved off and on, but I'm not involved all the time and don't remember everything. But I think what you have to look at in this case is what happened the first time. And what I would say is the court's opinion, the Court of Appeals opinion, was totally and internally inconsistent, because the claim was, you didn't give us this notice in the charging instrument. And the Court of Appeals says, but we don't stop there. We also look to the discovery, but we don't know what discovery was given. Now I think that's important, because after they decided, well, since we don't know what discovery was given, the trial court should have granted the motion to quash. But that wasn't the claim that was being made. The claim was, since it wasn't in the charging instrument, it should have been quashed, which is not the law. And Williams 2 makes that clear. Too many notes. As long as the charging instrument specifies all the manner and means upon which the state is permitted to rely, there is no notice problem. So, although they said, the panel said the trial court erred in not quashing, they were also treating it more as a notice problem than a charging problem. And what I would say is, I would agree with Mr. Bennett, is we don't know what discovery was given. But what I would say is, besides the fact that the court mixed up the two theories, what should be in the charging instrument and actual notice of what the state intends to prove, once they moved into the second theory.
Mr. Shulman, can you back up a little bit?
Yes.
I want to go back to the Court of Criminal Appeals opinion,
Okay.
because it does say that at most, the state would be required to allege more specificity in the indictment.
Correct.
You don't disagree with that, right? That they should have alleged more specificity in the indictment?
I absolutely disagree with it. They put in all the statutory possibilities. And okay, again, if we're looking at the question of what needs to be in the charging instrument, the law has been pretty clear for many years that if you have all the statutory definitions, that's all you're entitled to vis-a-vis the charging instrument. Now, you're certainly entitled to notice sufficient to defend yourself, but certainly in the Michael Morton era, and I would suggest since 1985 when they amended the Constitution, you get your notice through discovery, or one way or another. But if you're looking at it, what I would say is, while the Court of Appeals, Williams 1, was faced with, you didn't put this in the charging instrument, they resolved it on he didn't have notice. Okay? Well, if that's the issue, and Mr. Bennett is correct, the statute requires that both parties file a document about what has been given. But bear in mind that also requires the defendant to have done it. And this was a defendant's appeal. The defendant had a burden, and part of that burden was to bring a complete record. And I would suggest the better way for the Court of Appeals to have decided this the first time was to say, well, this gives all the statutory elements, and we can't tell what notice he got, and he's claiming he didn't have notice, he didn't bring us a complete record, it is at least harmless error. It was his burden to prove to the court what he got and what he didn't get, if he was bringing an actual notice claim, which he wasn't.
What is the practice in Kerr County with regards to the requirement of the statute under 3914 to sign off on a discovery acknowledgement?
Bear in mind,
Is there one?
I'm an out-of-town attorney. I have not practiced ever in Kerr County. I've appeared a couple of times in habeas cases in Kerr and Bandera, but I don't know. I would suggest that this, well, it's obvious in this case, neither side filed it. That's clear. But what is the standard practice? I don't know. The statute does require it. And all I could tell the court is, working in many counties, what I've seen is the compliance with that requirement, that both sides file the document, has gotten better over time. But again, my argument today would be, if the Court of Appeals had limited the issue to, do we have to change the indictment or amend the indictment, that's one issue, but it seems like they resolved it on the issue that, well, we can't tell that the defendant got actual notice, etc. Had they done it, we wouldn't be here today. It would never have reached, we wouldn't have reached this result. Now, I will tell you, I don't think many of you are old enough, but once upon a time there was this procedure called CLEP. You could go to college and say, I want to CLEP in and challenge a course, and they give you credit for the knowledge you'd acquired in the years you were at high school. I scored 20 points above the 99th percentile in English and grammar. I would also admit to you, I could not diagram a sentence. I would fail the 8th grade grammar test, etc. But I don't think that is important, because as was suggested, these 6 items about how you commit the offensive promotion are concepts, or words, but they're concepts which people understand in the day-to-day life. They don't need a special definition of manage. Manage means, and what was the question? Can't we just say the boss? Well, probably not the boss, but certainly we have different levels of management. This guy owns it and he's got the ultimate charge. Well, this lady manages the business because she's here day to day and tells everybody what's going on. Well, they're both managing. And the jury does not need to know how much they manage to say, well, yeah, that's a management type function.
But doesn't that go to the fair notice requirement? Are you alleging that he was the boss, or are you alleging that he was a helper? Those are very different things, right?
No. Yeah, one juror believed he was the boss. There's nobody else but him, and he's the manager. Well, if they believe that somebody else was directing all these things, but he's running this operation, and that juror believed he was managing.
You're going to the second point. I'm going to the first point, the fair notice. When he's preparing his defense,
Yes.
is he not entitled to know whether you're making the assertion that he was the boss or that he was involved in and supported it?
No, I'm not. And what I would say is the two issues are interlinked. It appears to me that the law is and has been for many, many years that the state does not have to elect on which of these manner and means it's going to go to the jury, subject to a motion for directed verdict. Everything that they put in the indictment, put on evidence, they can go to the jury on that, and the jury does not need to be unanimous on which of the manners and means. And to say that they would have to be unanimous on is he the boss or is he just a helper, that's not the issue. The issue is he performing a management function by implementing this person's directions? For quite a number of years, I was a shift boss in a casino. I didn't make the rules, I just enforced them. I just told people what to do based on that.
But your defense in that case is gonna be very different based upon whether you're the boss or somebody else. And so you keep going to the jury. I really wanna focus on fair notice and the motion to quash.
Okay.
And let's go back to the cooking the steak analogy, which I find to be very interesting. If in fact, I posited the idea that if the promotion of prostitution was cooking the steak,
Right.
and all of these are the grilling, roasting, frying, etc.
Right.
And he said the statute was not written in that way. How do you respond to that?
I think it's written exactly in that way. If the statute said, it's against the law to cook steak on Sunday, okay, and we proved that Sunday he grilled a steak, or maybe he boiled a steak. We're not sure, but he cooked it. And so some of the jurors believe, well, no, he boiled it, and some believe he grilled it. They both all believe he cooked it.
Well, one of you takes the position that the statute is not written in that way. You say it is written in that way. What law points us in one direction or another on that issue?
I would say the Court of Criminal Appeals opinion points you in that way, Your Honor.
In this case, Williams 2?
Yes, because it basically said, number one, that the distinction between elements and manners and means is forfeit or waived. But that notwithstanding is,
If you think their manner and means, what about the exception in Mays where it asks you to, give more of a description of each manner and means?
okay, and,
How does that apply, or does it
Okay.
apply?
right, and by that, we're then moving on to an actual notice question. And it was pointed out to me yesterday that I should point the court to the argument made by defense counsel in the trial, both opening statement and his closing argument. And it's pretty obvious he knew what was going on. He picked a defense, and the defense was not, well, he did this, he didn't do that. The defense was, he didn't do this. Those aren't
So
prosecuted.
as written, you think that's enough notice, the way it's written? If you just
Again-
track the statute?
It is absolutely enough notice in the charging instrument. My position, Your Honor, is that to the extent, and bear in mind, this was, the appellant was not claiming in front of this court originally that he didn't get actual notice. He was complaining the indictment should have given us the notice. But as to actual notice, he didn't bring a record to show he didn't get notice. And I think the argument that counsel made shows he got certainly adequate notice.
So, appellant's counsel mentioned that going to the burden on that issue of whether he got actual notice, that
Yes.
2119 says it's not reversible if it doesn't prejudice the substantial rights. How do you think the burden falls on that issue?
This was a direct appeal.
No, I'm asking about the burden. How does the burden fall? Who has the burden on that issue?
Whoever is the appellant. In other words, we're going to resolve this on appeal. The question, as I interpret it, is who had to prove to the court that notice wasn't given? I would say it was the appellant. The court here presumed, actually seems to have presumed that, well, it was the state's burden to introduce their discovery. And perhaps in a different issue, different case, it might have been, but the court is the one that raised this issue on its own. When they started talking about, we go beyond, it's not enough to just look at the charging, we have to look at this and this and this. And basically said, we don't know what discovery was given, right? But then they presume it's the state's burden, and I would say, in a direct appeal, where the defendant appellant has the burden of bringing a complete record and wants to make a didn't get actual notice record, again, that he didn't make, it would be his burden to show what he did get. And that's easily introduced nowadays because the 3914J notice would have given him an argument that he didn't get enough notice. So what I'm saying is the burden, to the extent that the burden came into play in the first decision, the court handled it incorrectly. What is today? Thursday. So let's say on Tuesday, in a case called Farias, the 14th Court, it's case number 1423-0505CR, 2 days ago, the Farias Court wrote that the state is permitted to plead alternative manners and means of committing the same offense without violating the right to jury unanimity. That is, to me, the answer to all these questions. The court has said you can't make the state get rid of one of the claims And the case law, effectively for the last 20 years at least, has said they don't have to elect in this situation. Now, in a perfect world, if they don't prove some of the manners and means that they've alleged, that would be subject to a motion for directed verdict. And if they didn't prove a particular manner and means, one, two, three of the 6, then the trial court could grant the motion to directed verdict, and the court's charge would, in theory, only have the other 3 manners and means.
Did that happen in this case? Was there a directed verdict?
No, there was no motion.
There was a motion.
Right. My recollection is there really was no objection to the court's charge, and that would require that Almanza would apply egregious harm. And again, if you look at the closing argument that defense counsel make, he certainly was not egregiously harmed. Unless the court has any other questions, I'll pass on the other 30 seconds.
Thank you very much. Mr. Bennett, before you start, can you address the issue about why we should use our discretion to consider the unassigned error?
Sure, because Theus dictates that when a case is remanded, it returns to the position on original filing. Court of Criminal Appeals has said so. In fact, I contend that you don't have discretion not to, but I contend that you have to address the error written, the error that has been argued here. Now, you might address whether it was waived or forfeited in the trial court, but Mr. Schulman wants this to, the pro se litigant's forfeiture in his appeal in which he beat the state the first time to be his only shot at it. He doesn't want me here. He doesn't want you to read my brief, and you can tell because he didn't read my brief. He doesn't talk about the cases that I write about, and I want to distinguish the cases that he writes about. The reason that the court has no discretion is Rule 47.1 of the Rules of Appellate Procedure. The Court of Criminal Appeals knows that this court does this thing because in Sanchez, this court did the very thing. It considered unassigned error, including a problem with the jury charge on remand, and the Court of Criminal Appeals had no problem with that. And the fact that it had no problem with it means it's permitted. The fact that it's permitted means 47.1 says it's going to have to be done. Now, you don't have to reach the unanimity issue if you decide the case in favor of Mr. Williams on the motion to quash issue. And on that, the record is complete, and there is no 3914J notice in the record. Mr. Schulman is pointing fingers. I think that nobody has the burden of showing harm in this case. I think the court looks at the record and says, does the record show harm? Does it show a lack of prejudice? But to Justice Brissett's question about the burden there, 21.19 is conditioned so that the default is a reversal on a formal error. It won't get reversed if this other thing happens, which implies that in any other circumstance, it'll get reversed on an error of form. There was no motion for directed verdict. If these are manners and means, there shouldn't have been. You don't get a directed verdict on a manner and means. You just ask that that manner and means not be included in the indictment, in the jury charge, because it's not the law applicable to the case. That didn't happen here either. The state has never argued that the record isn't complete. This is like, hey, 3914J is missing. The record must not be complete. There was no 3914J notice, and 3914 was therefore not complied with. And it doesn't matter whose fault it was that it wasn't complied with. Mr. Williams made the request for the notice that he's required to under Mays, and he didn't present that in this court, and therefore the Court of Criminal Appeals didn't consider that argument. They didn't reject the argument. They simply didn't consider it because, as I mentioned before, we're not entitled to this right result for the wrong reason review that the state gets to enjoy in the Court of Criminal Appeals. So and they didn't. When I got up to argue, Al-Kayali, The state prosecuting attorney, you know, on his rebuttal said, well, that wasn't briefed. And it's true, the unanimity issue hadn't been briefed there, it hadn't been briefed here, but we get to brief it on remand. And the question there is not waiver or forfeiture in the trial court, because of course jury charge error can't be waived or forfeited. It's an Almanza analysis, first of all, right? Was there egregious harm? There was egregious harm, because if you look at, you can tell I'm a big fan of Justice Urey, I'm sorry. If you look at Justice Urey's concurrence in Floyd, which the state pointed you toward in a supplemental brief, he talks about how the error was harmless in any case because there was definitely proof of all of the ways of proving the offense. Both of them, in that case, was an aggravated robbery. In this case, there's no evidence. And Justice Newell said in his dissent, there's no evidence of these three verbs, own, invest, or finance. And so in a way that the Floyd jury charge was not
Floyd,
harmful.
on that one, it's the same single specific criminal act. Are you saying that these 6 words can lead to maybe something that's not criminal? Or
I
Kinda
don't
explain-
understand the question, I'm sorry.
in other words, it's a result-oriented crime, and it's saying in Floyd that the jury must unanimously find that the defendant committed that crime in one specific way or even one specific act, but then it says that if they all lead to one crime being prostitution, right?
Well, no. So in Floyd, it was aggravated robbery.
I
And
understand
aggravated
that.
robbery is a very different sort of statute. The state says in their letter brief, oh, this is exactly the same thing. It's not exactly the same thing. If you want to look for exactly the same thing, look at a case called NGO, N-G-O, from the Court of Criminal Appeals, 2005, I think, in which the state, and I wanted to get this in because the state relies in their brief on Shad and the moral equivalence of various acts. It's rejected in NGO. If you look at the NGO case, which is in my brief, it's on 6 or 7 different pages. It's not in the state's brief. They don't want me here. They don't want to address the actual arguments. They want this to be forfeiture or waiver. So the difference between, I don't disagree with Floyd. I wrote a motion for rehearing in Floyd because I thought that it would be, that we could still fight about that, but I don't disagree with the result in Floyd. The aggravated robbery statute incorporates the robbery statute. So essentially, in the aggravated robbery statute, robbery is an element. And you can commit robbery in one of 2 different ways. So robbery by threat and robbery by injury are 2 different manners of committing robbery, and I don't have any exception in an aggravated robbery case with allowing the state to tell the jury, look, you don't have to, the underlying robbery could be either one, but if he did this thing and he had a gun, then that's a first-degree felony. So I don't disagree with Floyd. It's not on point.
If you have to write this opinion and your position is you win on the first point that the motion to quash should have been granted under Mays,
Yes.
how do you justify that? How do you walk me through that?
Sure. Mr. Williams explicitly requested and preserved the error in the trial court. At the time that the motion was ruled on, with all of the information that the judge had, he should have granted the motion, because all he had at the time was the indictment. Now, if the record then showed that there was further notice given and that cured the problem, then that would be a 21.19 lack of prejudice to his substantial rights, but we don't have a record of that here. That's what I would say. You judge the error by you don't look at what happened afterwards to judge whether whether it was error. You look at what happened afterwards to judge whether it was harmful. So that's how I'd write it. I would say it was a well-taken motion. These are undefined terms of indeterminate meaning, and therefore the trial judge erred in granting in denying the motion to quash, and the record doesn't show the second half of 2119, which is a lack of prejudice to substantial rights. May I? May I write it? So the jury charge issue can't be forfeited. Nothing that was forfeited in this court remains forfeited because of Theus, and we have Sanchez as the concrete example of that. We have Ngo as the concrete example of the Court of Criminal Appeals rejecting this Shad woo, it's a morally equivalent argument for whether things are elements or not. That wasn't a Sixth Amendment case. It was a procedural due process case. There's nothing more woo than a procedural due process case. Moral equivalency has no place in an appellate courtroom. It's so vague. It's who knows what the moral equivalence of things are. If I hit Nick on the back of the head today, it's morally equivalent to me hitting him on the back of the head yesterday. But there's no way we would say to a jury, well, he's charged with doing it today or yesterday. You don't have to be unanimous on which it is because they're morally equivalent. The Court of Criminal Appeals, in this case, called them statutory methods. I think that's just as important as Judge Yeary referring to them as theories of committing the offense. They are value-neutral words in terms of are they manners or are they elements. The Court of Criminal Appeals expressly declined to decide on this issue. I happen to have been the lawyer on Farias, which was decided yesterday, 2 days ago. I happen to be the lawyer on Farias. It wasn't preserved in the trial court, and it was a whole different statute. So Farias doesn't add anything to this discussion, but we'll take it up and we'll see if we can get the CCA to help us out there as well. The error was structural, the harm was egregious. Look at Judge Yeary's concurrence in Al-Khayali. The state's substantive cases are all wrong. Ringer wasn't about whether the jury had to be unanimous. It was about whether the jury had to find all of the elements to be true. Ringer and all of the state's cases preceded Ramos, Apprendi, and Elaine. Shad is woo. The state didn't address the actual statutory definition of element. They started out by saying there's no statutory definition. There is. 1.07A22, element of the offense means. And with that, we pray that the court, again, reverse the judgment of the trial court, remand with orders that the case be dismissed, and we ask that when it do so, it immediately set bail on appeal for Mr. Williams again. Thank you.
Thank you. We will take the case under advisement with opinion to follow. Thank you.
All rise.